Hello everyone, myself Aishwarya, a legal intern at LEXIS and Company, and my topic for today is adoption. According to Manu, adoption is the taking of son as a substitute for the follower of a male issue. This is a transplantation of a son from one family in which he is born another family where he is given a natural parents by a way of gift. Adoption is a legally recognized mode of affiliation as a son of a person of one who is fact was not his son. On adoption, ties of the son with his old family was severed and he is taken being born in a new family, acquiring rights, duties and status in a new family. Now, in present scenario, Hindu Adoption and Maintenance Act 1956 has completely codified the law of adoption and has materially modified in correspondence to need of a dynamic of Hindu society. Therefore, every adoption shall be made in conformity with the Act of contraventions of provisions. This act shall be void. There are some essentials of valid adoptions, which are, as per section 6, the Act enumerates the requisites of valid adoption. First one is the person adopting has the capacity and also has a right to take in adoption. The person giving an adoption has capacity to do so. A person adopted is capable of being taken in adoption. Last one is the adoption made in compliance with other conditions mentioned in this chapter. Therefore, no adoption is considered valid unless it fulfills the above mentioned conditions under section 6 of Hindu Adoption and Maintenance Act 1956. According to section 5 of this act, an adoption made in contravention of the provisions of chapter 2 of Hindu Adoption and Maintenance Act 1956 is void. Then capacity of a male Hindu to take adoption. In this, according to section 7 of Hindu Adoption and Maintenance Act, any male Hindu who is a sound mind and is not a minor has the capacity to take son or a daughter in an adoption. But if the male Hindu has wife living at the time of adoption, he shall not adopt except the consent of his wife. Second one is capacity of the female to take adoption. Then a female has also a capacity to adopt any child. As per section 8, the act provides any female Hindu who is a sound mind and who is not minor, who is not married, or if married, whose marriage is dissolved, or whose husband is dead, or her husband has to be re-announced the world finally, then consequently her husband has become unconverted, or her husband has been declared to be an unsound mind by a court of a competent jurisdiction, has a capacity to take son and a daughter in adoption. Then last one is person capable for giving adoption. Section 9 of the act lays down as a capacity of a person who may give the adoption to another. No person except father or mother or guardian of the child shall have the capacity to give an adoption. Thank you.